The life of law is not logic, it is experience. Welcome to the world of American legal realism, a school of thought that sought to attack formalism on two main grounds. First, they thought that common law was not as neutral and objective as it claimed to be. And second, they didn't think that general legal concepts should determine outcomes in certain cases. But before we move ahead, it's important that we introduce you to the key figures of this story. The first key figure is Oliver Wendell Holmes Jr., a Harvard Law School graduate, a justice of the Supreme Court of the United States, and someone often credited as the founding figure of American legal realism. The second key figure is Christopher Columbus Langdell. He basically was the antithesis of Mr. Holmes. Christopher Columbus Langdell developed the case law method for learning law, equating it to a science of sorts. The third key figure is Roscoe Pound, a sociological thinker who focused on the real-world implications and spoke about law in books versus law in action. But first, on the theories of Oliver Wendell Holmes Jr. Holmes believed that to understand law in its entirety, we should be viewing it through the lens of a bad man. In the everyday interactions of people and the law, he believed it's important to understand what were the outcomes of a certain decision. And hence, a lawyer's job, in his view, was that of prediction. The ability to be able to predict something, and being in the legal field, this prediction would be relatively easier since law was not an exceptional occurrence and happened to be a relatively well-known field. On questions of law and morality, Holmes believed that the connection between law and morality was not absolute. He spoke about two nuances on this. First, that law isn't necessarily able to keep up with changing ideas of morality, and second, that people don't necessarily care about law because it's related to morality. Both a good man and a bad man would have it in their interests to know about the outcome of a legal proceedings. The second main concept of American legal realism was about judges and about how their prejudice often creeped into their judgments. Roscoe Pound, a sociological thinker, spoke on the idea of law in books versus law in action. His first main focus was judicial decision making. The realists too, in their attack on formalism, often joked about how judicial decisions have a basis in what the judge ate for breakfast that day. What the realists meant when they spoke about the same was that decisions often have political, sociological undertones, but also decisions are sometimes made on hunches. By doing this, they tried to urge the people to focus more on the sociological aspects of law and its public policy impacts. This was against what Christopher Columbus Langdell sought to achieve through his case law method. He sought to derive law from generally accepted axioms and derived it through logical deductions. To sum it up, the realists like Oliver Wendell Holmes and Carl Lulan believed that the black letter of law did not reflect how it actually played out in the world and did not account for changing morality of the world.
So we went around campus asking students from different disciplines general questions like, should a lawyer defend a terrorist? Should a feminist lawyer defend a rapist? They had no idea as to what legal realism is or formalism is. But their answers tilted to one of these sides, which only goes on to show how prevalent these schools of thought is in today's time.
Do you think a feminist lawyer should defend a rapist?
Okay, so how long do you want each answer to be?
Like 10 to 15 seconds.
Okay, my answer is no. Because I remember one of my very first litigation internships, I was supposed to draft an anticipatory bail for a man accused of rape. And I refused to do it, and the associate was basically like, you're in the wrong line of work if you're going to think like that. And I was like, maybe I am. But yeah, I think to go against your very principles in order to cash out and make some money, goes against, for sure, yeah.
Thank you so much. Okay, so do you think law is as messy as real life is?
I think that law is more messy than real life in many situations because law tries to mirror real life but does it inaccurately, and it's very ambiguous, and sometimes it's very inconsistent with moral principles, and I think that law doesn't account for the morality and ethics that people apply within their real life also.
So do you think a lawyer should defend a terrorist?
A terrorist. I feel like it is more of a prerogative of the lawyer itself, because when it comes to defending people, I think everyone has a right to present themselves in court, and they do have the principles of natural justice. They do have the right to basically tell their part of the story, and for that they obviously need a lawyer. So yes, I feel like lawyers should also defend terrorists, because they also have a chance, they also have the right.
Do you think a lawyer can predict the outcome of a case?
I think the possibility is yes, that the lawyer can, if the lawyer is experienced and has a lot of knowledge in the particular field. I think a lawyer can predict the outcome of it.
What do you think a judge should rely on while making a decision?
I think a judge should rely on first of all, the law that is in place, that is the statute, then also the facts and circumstances of the case, then also the principles of fair rule and fair hearing, obviously.
Moving on from the Supreo versus Union of India judgment and the debate about whether it was a formalist or realist understanding of the law, our next segment is going to highlight previous examples from India of courts stepping outside the demarcated bounds of codified law and acting based on embedded biases. How do their personal biases impact rights protections under the law? Firstly, why would a judge rule on factors other than the law? And what could those factors be? Prejudices, personal biases, sympathy or a lack of sympathy. Towards whom? Witnesses, lawyers, parties. Testimonies of witnesses which may be biased by personal characteristics and fact skepticism. All of these affect a judge's credibility and decide what they choose to apply emphasis on and which way they choose to interpret the law when arriving at a judgment. Does minimizing focus on the formal code of the law and widening emphasis on the moral, social and political preferences of judges have a positive impact on legal protections of persons under their jurisdiction? Judge-made or judge-interpreted law has often led to rights protections not explicitly enshrined in the law. Indian law, for example, did not codify or recognize queer identities and their rights and protections. While it still does not recognize gay rights in codified law, transgender persons specifically were recognized within codified law only after the court created a right to self-identify your own gender and directed the central government to take necessary protective action in Nalsa versus Union of India.
Many laws were often defended irrespective of their blatant overreach into a citizen's privacy on the grounds of privacy not being an explicitly recognized right in the Indian Constitution. In the K.S. Puttaswamy versus Union of India judgment, a right to privacy not explicitly present or codified in the Constitution was read into Article 21. Article 21 of the Indian Constitution reads, "No person shall be deprived of his life or personal liberty except according to procedure established by law." The strict word of the law essentially allowed deprivation of life and personal liberty through the establishment of any law whatsoever, however arbitrary, violent and irrational. In the Maneka Gandhi versus Union of India judgment, however, a combined reading of multiple articles held that procedure established by law must be free from arbitrariness and irrationality. This not only was a judge-made law essentially, it also allowed the scope for the creation of more judge-made law, as the judge's discretion would decide what is arbitrary and rational and what is not. This does not mean that the influence of judicial bias has always been positive. Section 375 of the Indian Penal Code, dealing with rape, defines consent in explanation 2 as unequivocal voluntary agreement when a woman by words, gestures or any form of verbal or non-verbal communication communicates willingness to participate in the specific sexual act. What is clear from the codified law here is that the agreement to sex must be voluntary and unequivocal. In the case of Mohammad Farooqi versus State Government of NCT of Delhi, the defense quite literally argued that it is not unknown that during sexual acts, one of the partners may be little less willing, or it can be said unwilling. It matters not if one of the parties to the act is a bit hesitant. The court sadly held that despite the prosecutrix saying no and pushing the defendant off her, because she was not a conservative person and intellectually and academically proficient, her feeble no was also valid consent. The court set out a separate standard for educated modern women who have had prior sexual relations with the persons they accuse of rape. Such classification is not demarcated in the Indian Penal Code.
While biases and considerations of the social pulse have had positive impacts on right protections, it has also had ghastly outcomes like those in Muhammad Farooqi, and debates around whether rights would be better protected by formalist interpretations or realist interpretations of the law continues to rage on. We'll be back next week at the same time with a panel of scholars to discuss new controversies around electoral bond transparency. You're watching Times Now. I'm Aditya Abraham with my co-host Tanushri Gupta, cameraman Gianna Bajaj and director Kavisha Podar. Thank you for being here today.